Good evening. My name is Tanya Lowe, and I'm one of the moderators for this evening. On behalf of the Treasure Coast chapter of the Links Incorporated, I'd like to welcome you to a very important conversation this evening about wills, trusts, and estate planning. Throughout the course of our webinar series, we've talked about smart money moves, as well as taking control of your credit, finding your first home, and tonight we want to talk about how to protect your home and other assets with advanced planning, wills, and trusts. Next slide. We do have a few tips for housekeeping. First, this webinar is being recorded. Each participant is asked to remain muted at all times. Please enter your questions in the chat box, as we will have a Q&A session that will follow the presentations. Next slide. Also, before we get started, if you will, we like to test your knowledge about wills, trusts, and estate planning. So please take a moment to open your camera app and hold your device over the QR code until your device recognizes the code. And then just tap on that notification to open the link to test your knowledge. We'll give you a few minutes to answer a few questions about wills, trusts, and estate planning. If you will, take a moment to enter in the chat, those of you who received 100% on your testing of your knowledge. How many received 100%? Anyone? Well, throughout tonight's presentations on advanced directives and wills and trusts, you'll have the answers to those questions, very important questions, as we hear from our phenomenal speakers for this evening. Our first presenter, next slide. Our first presenter is Ms. Maricela Salazar. Ms. Salazar is a registered medical assistant, and she's worked in the medical field for more than 20 years. She's working with Florida Community Health Centers Incorporated since 2005, where she's worked as a case manager for the organization since 2017. When asked why she has such a passion about the healthcare field, she attributes this to watching the struggles her father encountered as an illegal immigrant. She knew she wanted to do something to give back. Her parents worked extremely hard doing agriculture work, including picking fruits and vegetables, sometimes on the hottest of days. They made many sacrifices so that she and her siblings could have a better opportunity in life, including a quality education, and she never wanted to take that for granted. Ms. Salazar, as she matured, she continued to learn of the many struggles that migrants deal with, including the inability to speak English, lack of knowledge, education, and even comprehension as it pertains to their health care. Working in the medical field with Florida Community Health Centers has given Ms. Salazar the opportunity to assist others in similar situations. And she's humbled by the work that she does each day as she finds it very rewarding. That's our first speaker for this evening. We will also be joined by Yvette Simmons, Esquire, of Simmons, Feeney, and Winfield, LLC. Ms. Simmons is managing member of Simmons, Feeney, and Winfield, LLC, a minority-owned law firm, a minority-owned women-owned law firm with offices in Florida and Georgia. She received her undergraduate degree from Florida Southern College, her law degree from Mercer University, Walter F. George School of Law, and an honorary doctorate of laws from Suffolk University. For many years, Ms. Simmons has practiced law in the areas of estate planning, probate, guardianship, and contract law. Her firm provides litigation, criminal, commercial, family, employment, mediation, and other legal services in an efficient and expeditious manner. Ms. Simmons has lectured in the areas of probate law, guardianship law, estate planning, and diversity. Her publications include Inside the Minds, Building and Encouraging Law Firm Diversity, A Special Bowl of Oatmeal, The Sunday Before Christmas, Sun Up to Sundown, Revisited Again, and Black History Poems. We will hear from Ms. Yvette Simmons, Esquire, on Wills and Trust, immediately following our session on advanced care planning session with Ms. Salazar. I'll turn it over to you.
Thank you. Thank you. Can you guys hear me? Wonderful. Okay. Well, thank you so much for the invitation and allowing me to be here tonight. Thank you for the introduction. I truly appreciate that. When you said 20 years in medical field, I was like, oh man, I'm getting old. I can't believe how time has flown. But yes, it's been 20 years in the medical field. And honestly, I would never, if I could do it all over again, I would not change my career. It's so rewarding. Okay. So tonight I am going to talk about advanced care planning. It's super important, and I think that it's wonderful that you guys have this program to where you're teaching your communities about this, because a lot of people don't know how truly important this is, okay? So I'm gonna go ahead and start. If you could go to the next slide, please. Okay, so what is an advanced care plan? An advanced care plan, what it does, it allows the patient to discuss your healthcare wishes if you become unavailable to do that yourself. Okay. Next slide, please. What are some of the healthcare directives? So advanced directives allow the patient to appoint an agent or record a patient or a person's wishes that about their medical treatment based on their values and their preferences, okay? An advanced directive affirms the patient's choices about any medical care or treatment, or it will name someone to make those decisions about their medical care if that patient is unable to make those decisions themselves. So it's a document that's going to tell medical staff what you want done in an instant that you cannot make those decisions. Medical staff, doctors need to know what is it that you want done. And it's important that you document that, or you assign somebody that you trust to let us know who can we turn to when you're unable to make these decisions, okay? It's called an advanced directive because it is signed in advance to let us all know your wishes and concerns, okay? Next slide, please. So there are two types of directives. The first one is a living will declaration. This document generally states the kinds of medical care that you want or do not want, okay? If you are unable to make those decisions. Number two is the designation of a healthcare surrogate. This document allows you to appoint somebody to make these decisions, okay? This is often called surrogate or an attorney in fact, okay? It's the same definition. So this person, we're going to look for this person and we're going to ask them, you know, what does Ms. So-and-so want done? This person should be somebody that's close to you. This person should be somebody that knows you and somebody that you trust to make the right decision and to do what you've asked them that you want done, okay? So those are the two different types, a living will declaration and a designation of a healthcare surrogate. Okay, next slide. So we attached an example. This is the first example here is a more basic one. And it's just here so that you can kind of review it. This is what it should say. There's hundreds of living wills on the internet. They all look different, but typically this is what it should be looking like. It should have an area where your name goes. And it should say, do you choose to prolong life or do you choose not to prolong life? And I'll go over what that means. Number two is, do you want pain medications? Okay, some people don't want any meds. They don't want any antibiotics. They don't want anything. So that's your choice. Number three is other wishes. Most people, I had one gentleman once put that he wanted his body donated to a university for science. So that's where you would put that. There's also an area for you to put your primary care doctor. That is optional. I always recommend to the patients to put that information so that we can reach out to the doctor if we have any questions. Number five is organs. What would you like us to do with your organs? There's people that do want to donate, and then there's people that do not. And again, this is just an example, but they should all typically say the same thing. There's an area where you have to sign, and then a witness, and then the signature of a notary. Okay, so this is just an example of the first one. This is more of a basic one. Could you go to the next slide, please? So this is the one that I give out in my office more. This one is a little more detailed. So at the beginning, again, it has the area where you're going to put your name, and it's going to identify if you go into a terminal condition, end stage condition, or if you go into a vegetative state. And I will go over what those things mean. You would initial off. If you unfortunately fall into any of those things, the will kick in, okay? It's going to ask again about the organs, and it wants a witness. You have to have that witness. If you could go to the next slide, please. And then this is the area where you would assign somebody to speak on your behalf if you cannot make those decisions. So that's why I like to use this one, because you can actually put on there who you want to assign, and that person also can have authorization to make a decision concerning your organs. So this one is the one that I use. Principal signature is always the patient, and then again, the witness. I also like this one because on the third page, you can see there's like little wallet sizes. Those are always so important to have, because you can just carry it in a purse or in your wallet or somewhere, you know, where, God forbid, they find you unconscious, they can just pull that and we'll know what to do. Okay. So those are my two examples, but like I said, there's hundreds of them on the internet. You can go on, you can scan through them and choose the one that you would like to use. Okay, next slide, please. Okay, so difference between a living will and a living trust. Is there a difference? Yes, there is a difference. And I can't tell you the number of times that I go to a patient and I let them know, hey, you know, I need to take a few minutes to talk to you about your living will. And automatically they're like, no, I already know my son is on, you know, he knows what to do with my house. My daughter's on my bank account, you know, everything. And I'm like, no, that's not what I'm talking about. You know, that is more of a living trust. I want to talk to you about medical issues and decisions and concerns you may have. Living trust is more of the financial assets and the properties. Although they do use living will to describe those financial assets, that's not the living will that I'm talking about. I'm talking about medical decisions that people need to make. And so sometimes they get those confused. We just break it down and let them know what the difference is. Okay. Next slide. Okay, so some most common end of life decisions for patients is as follows. The first one is the cardiopulmonary resuscitation, also known as CPR. This is really important because this is a procedure that can be used to save your life if your heart stops or your breathing stops. When your heart stops, you go into what's called cardiac arrest. So they're going to start chest compressions to mimic your heart, okay, to keep the blood flowing to your brain so you don't become brain dead. What I like to tell patients, and what's important for everybody to realize, including the family, is that CPR is not like in the movies. It's not pretty, okay? A lot of people don't realize that. CPR is very traumatizing and it's very hard on the body, okay? So yes, it can save your life. But people need to realize that, I'm 40, I want CPR done because my children are still young. I don't even have grandkids. So you can go ahead and do CPR on me. During CPR, bones break, ribs break. It's very traumatizing. Personally, me, I don't care, you can break my ribs, I will heal. But when you're talking about a 92-year-old, 100-pound elderly person, and they got a nurse on top of them who's 163 pounds, that is hard. That is hard on that body. That elderly person might not want that, okay? But people have to let us know. Prior to COVID, they would always allow family members to come into the ICU rooms and they could visit their family members. And if they call a code blue and those family members are there, that is very scary. When a staff of 15 come in and they're working on your loved one and they're pumping their chest and they're sticking tubes and they're sticking, that is very hard to watch. So that's why people really need to think, oh, CPR, it is not like on Grey's Anatomy. It is not like on the soap operas. It's not, it's difficult on the body. A 90-year-old is not going to heal like a 40-year-old, okay? So people have to take into consideration, they need to talk to their loved ones. Do you want, a nurse, doing chest compressions on your grandma? Some people might, and that's fine. But they have to realize it's not pretty, okay? But it can save a life. It can. Okay. The next one is the Do Not Resuscitate Order, also called a DNR. And that is exactly that. It's a you do not want to be resuscitated. This order it comes from the doctor. I don't hand out DNR orders to patients because it actually has to be a physician who approves that DNR. Okay. So that's just it. You do not want to be resuscitated. If you code, something happens and you have a DNR order, staff is not going to do anything to try to bring you back to life. Now, if you do code and you don't have that order, staff is going to do what they have to do to bring you back. Okay, so that's important because if you don't have that and you just want to be left alone, that's not what's going to happen. Staff is coming in and they're going to start to do what they got to do to save your life. Okay, so that's really, really important to get from your doctor and to attach it to the living will. Okay, the next one is a do not intubate order. That's also called DNI. And this is an order that you do not want to be intubated. You do not want a tube down your throat. Okay, this is important because if you tell us you don't want to be intubated, you don't want a tube down your throat to help you breathe, that's fine, but it does not tell us that you don't want CPR. So we will do the CPR. We just won't intubate you, okay? So people need to realize that if you say, I don't want intubation, that's fine, but consider the CPR because we're still coming in to do chest compressions and try to bring your heart to beat naturally again, okay? That's what intubation is. The next one is artificial nutrition and hydration. This is a treatment that allows patients to receive food and fluids if they cannot eat through their mouth. So what they'll do is they'll put a tube in your nose and feed you like that through an IV, or they can go in through your abdomen as well and straight into your gut. So these are different ways that they can get nutrients and fluids into your body. You also have the choice of that. Medical ventilation, that is the respirators. This is a machine that you're attached to that helps your lungs breathe, okay? And dialysis. So the kidneys, what their function is to remove waste and toxins and like extra fluids. If your kidney starts to fail, you have a choice to get on dialysis, and it is a procedure, a treatment, and it does the job for the kidneys when the kidneys aren't functioning anymore, okay? Can I get the next slide, please? Okay, more decisions and questions. Medications. Sometimes patients don't want medications. They don't want to be on pain meds. They don't want antibiotics. They don't want antiretroviral medications or whatever. And that's fine. That's your choice. You just got to let us know. Organ and tissue donations. Again, let us know what you would like to do. The donations, you want to donate your body to, you know, some college for studies, let us know. And two really important questions. Is the patient's living will valid in another state? I get these questions a lot because we get a lot of Northerners come down. So they'll have their wills from Massachusetts or New Jersey or somewhere else. And they'll ask, you know, is it valid? In Florida, Florida does honor out-of-state wills. So yes, for Florida. Not all, most states will validate a will from Florida, not all of them. What I tell patients is you have a Florida will, make sure when you get to New Jersey or wherever you're going for the next 3 to 6 months, make sure that it's valid. In Florida, we will honor those wills, but you know, in different states, you know, I always advise the patient to make sure that that will is valid, okay? Next slide, please. Okay, so this is the important terminology that's going to be in your will, and it's important for patients to understand. Life-prolonging treatments. These treatments are CPR, they're the dialysis, they're the respirator, okay? These are all the treatments that we have, that we can offer to the patient, but it's important to know that it's not a cure for the illness or the disease. If you choose dialysis, you're gonna be on dialysis, but it's not gonna, you know, it's not gonna cure the kidney disease, okay? So it's not a cure, it's just going to help you. Terminal condition, that's important. So this is a condition, excuse me, I turn the light on. So this is a condition that is incurable, okay? We can administer some medical treatment to prolong the dying process, and I know that sounds kind of harsh, but without these treatments or procedures, death will approach quicker, okay? That's what terminal condition means. Vegetative state, this is a permanent coma or unconsciousness, okay? That's caused by some type of illness. The patient is typically unaware of their surroundings or their environment, and to some degree, there is no recovery from that. Okay, so that is what vegetative state means. Okay, and then there's an end stage condition. This condition is irreversible. It is caused by some type of injury or a disease. It could be severe, and typically it's permanent and it like deteriorates the patient. Okay, so again, to some reasonable capacity, medical treatment is going to be of non-effect. Okay, so those are the definitions to that: end stage, vegetative state, and terminal condition. Okay. Next slide, please. Okay, so making changes to your living will. The patient can make changes to their will at any time that they want and they choose to. The advice that I always tell people is if you choose to make any changes at all, please make sure you make your copies, make sure you distribute those copies to the appropriate people, including your primary care physician, your loved ones, the person that you appointed to be your power of attorney, and then throw away the old ones. Throw away the old ones so there's no confusion, okay? Reasons for changes are new diagnosis, changes in marital status, and any changes in wishes. Okay, so, but they can be made at any time with no issues. Okay, next slide, please. Signature and witnesses. Living wills must be signed and dated. I can't tell you the amount of times that patients come in, they drop off their will, I go and get it to scan it into their chart, and it's not signed. So then I got to call the patient and be like, hey, you got to come back and sign this. So please make sure that you sign and date your living will. Okay, living will must be witnessed, and at least one of the witnesses should not be a blood relative or a spouse. Okay. Next slide, please. Okay, so just some important reminders for patients. Please remember to keep the original copy in a safe place, but somewhere that's accessible easily. So if you're gonna lock it up in some box in the back of your closet, make sure that somebody else has the key to that, because it's really important that we get to that. Give copies to your healthcare providers. Give a copy to your selected power of attorney. Please continue to speak to your family and friends and loved ones continuously about what you want done. Please, please, please. It's super important. Make the changes on the will as you need. And it's really, really good to carry a wallet-sized card with you. Again, if you're unconscious somewhere and you have that with you, it's so super awesome that we can just pull it out real quick. And next slide. So that is it for my part, you guys. I was faster than what I thought it would be, but thank you guys. Are there any questions? Should I look in the chat box? For posting.
Yes, please check the chat box.
I don't see any. Do you guys see questions? Oh, I see one. So what if the patient changes his or her mind about the DNR or other care at the last minute? Like last minute, like before you become unconscious? I mean, if you're unconscious, you're not able to make those choices. So, you know, how last minute are you talking? Like, are you talking about like how last minute are you talking? If you're talking last minute, like the day before you go into some type of surgery, you know, you could still make those changes, but you have to have a witness and make sure that you carry it with you to the hospital. Can I get the next one? Can I get a form from my doctor? I guess that's it. You can get them online. I don't know if every doctor office has these, but you can pull them offline if you want. I don't know if every doctor's office has those. And what else? Is that it for questions? I hope I answered those questions correctly. I don't see any other questions. Do you guys see any?
Tanya and Helen, will you please unmute to assist?
I don't see any other questions in the chat.
Oh, I see one.
Well,
I see
I just typed one.
the 18. Yes, you have to be 18. Yes. Yep. But if anybody wants copies, I can put my work email into the chat box, and I don't mind talking to anybody about this. I can, you know, email you, you know, some of my examples. I can help you over the phone if you'd like to come and see me. I'm in Indiantown. I don't have an issue with that. Let me go ahead and put my email, my work email in here. And you guys, please feel free to reach out to me. I am available. I am here to help you guys. Advanced care directors are so very helpful to the medical staff, but more to you. Like, do it for yourself. If you don't have this in place, the medical staff is going to do what they think is best. And that might not be what you want. Okay, so it's super important that you get this. And you don't have to be, you know, I've had patients tell me, oh, you know, I'm not old, I'm not ready to die. And I'm like, look, nobody has their death date on their calendar. You don't know. Again, I'm 40 years old. I could plan to go to work tomorrow, and on my way to work, God forbid, I get into a car accident. I need, I don't want to leave that responsibility to my children where they're deciding what I want. It's in writing. They can take it to the hospital and they don't have to stress about it. Okay. So it's super, super important. That actually is my personal email. Let me put my work as well. And this is my work. My work, the fchc.org is the one that I look to the most. So if you guys have any questions at any time, please, please, please feel free to reach out to me. I'm always available to help you guys.
And I also want to mention to all of our participants, again, thank you so much for joining us for this very important conversation. We do have a copy of the forms for the advanced directives. They are, it's a PDF that has been attached to the chat. So you do have access to that form that Ms. Salazar shared with us this evening. Thank you so much, Ms. Salazar. We do appreciate the time that you spent with us this evening to share with us about advanced directives and as well as the form. I think that was really helpful for us to actually see what the form looks like and how to get that filled out and how we need to be specific about our healthcare providers, the persons that we are choosing to make those very important decisions for us. I think it was also helpful to learn that those who witness those signatures cannot be a blood relative. That we do need to make certain that we are have that advanced directive in place so that there are no surprises for any of the family members as well.
Right. Yep. And that's super important. And that, yes, that's very important. Well, thank you guys for having me. And I know there was more question. Do I have to be at least 18 years old? Yes, you do have to be at least 18 years old to get that done. So last question, but thank you guys for having me. Thank you for inviting at Florida Community Health Center. It was a pleasure. I have to admit, this is the first time I've done it. I was so nervous. I've been nervous like all week long. And then like my boss, she was like, I'm gonna be there in the background. And I'm like, oh my God, you're not making this any better. But thank you guys again. It was a pleasure. It was a really, really a pleasure. Thank you so much.
You did a fantastic job.
Thank you.
Thank you.
Thank you so much. I will now transition over to Ms. Helen Lurie to get us started on the second part of our presentation this evening.
Well, thank you, everyone. And Ms. Salazar, Maricela, we thank you again for that amazing presentation.
Thank you.
That information is so important. For all our participants, as you can see, we have been working diligently to give you the information that you need for all the different stages of life, from home ownership, credit, budgeting, and now medical advanced directives. And now we're transitioning to Ms. Yvette Simmons Esquire, who will be talking about estate planning for the layperson. And at this time, I introduce to you Ms. Yvette Simmons.
Hello, can you hear me now?
Yes, loud and clear.
Okay, then. Hello, everyone. Hopefully I can be as substantive and as brief as Ms. Salazar was. What is estate planning? I mean, estate planning is, there's really no definition in statutes or no definition in case law, but estate planning is basically identifying and managing your property. It's everything you have. And it's not just physical property, but it's all planning, including what Ms. Salazar was talking about. It can be property that you have now, or it can be property that you're going to have in the future as a result of a relationship with someone else, a parent. You may be an heir, or a marriage. You may be married and your spouse may have assets. Estate planning can be dictated by your immediate needs, as well as your relationships, as well as your assets. And that is, you might have situations where you may have children who are not the most responsible, or you may have situations where you may have a spouse who may be incapacitated. All of those
Right.
questions go into the issue of how do I prepare my estate plan? If you could go to the next slide. Estate planning can give you peace of mind, because what it does, it clarifies what you want to do with your assets, and possibly what you want to do with the assets of those that you are caring for. And it doesn't have to be probate. That's why you plan, because probate can be very expensive. Estate planning can also include property that you have not just in Florida, but in another state. And sometimes people may have property in Florida and property in Georgia, and not realize that there may be methods to avoid having to have probates in two states. Estate planning can cause you to accelerate distributions, that is gifting. I mean, if you give a gift to someone of 15,000 or less, then there is no tax consequence, no gift tax consequence to you. But the important thing is that it clarifies your current, your future, and your final wishes. Next slide. And it can be simple, which would be a will, power of attorney. You heard about healthcare directives, living wills, all of that's included in estate plans. Or it can be more complex. You have trusts, revocable trust, irrevocable trust. We'll talk about that a little bit more. But and it could be quantified in the form of ownership, meaning that you can prepare your documents. You can prepare the ownership of your property in such a way that it avoids probate altogether. Next slide. Estate planning is interesting. I just today saw a will where a man that passed away, he had a wife. It was a second marriage. He had a child from the first marriage, and he prepared a will. He prepared 4 deeds that left all of his property to his son, and said, don't record these deeds until after my death. And he left everything to his son, and his spouse was still living. Now, Florida law is that you can't disinherit a spouse unless that spouse chooses to be disinherited by virtue of signing a prenuptial agreement, postnuptial agreement, a disclaimer. And so all of that sneaking around meant nothing, because that spouse was still entitled to 30% of that estate. So estate planning is saying, if I don't want my spouse to get something, but if that spouse has to get something, what I'm going to include in my estate plan, what that 30% would consist of. Another thing about estate planning is that you can prepare your plan and then you remarry. If you fail to redo your plan or your will, and not acknowledge that pre-demitted spouse or that new spouse, then that spouse can inherit as if you had no will. So it's amazing, and why it's so important to plan, because what you think will happen does not always necessarily happen. Also, with estate planning, when you have a have a home and you marry, and you did not include that spouse on your home that you had before, and you were thinking, well, that house is going to go to my children, and you failed to have a will, then that spouse, even if sometimes even with the will, that spouse is entitled to a life estate in that home. So those are types of issues that have to be considered in your estate planning to make sure what you hope to accomplish actually is accomplished. And if you distribute the property during your lifetime, and sometimes we tend to give something and then we decide, particularly with real estate, then we want to take it back. It doesn't quite work that way, because once it goes from you, it's gone from you, unless you have a means by which you a right you kept with it to be able to take it back. Next slide. I thought Ms. Salazar was going to talk about powers of attorney, but estate planning includes your powers of attorney. What that is that's giving a person the ability to be able to make usually financial and property decisions for you. I always say that when you're planning, you have to plan for 3 stages. The stage where you are now, where usually things are going fine. Then the stage where you might be incapacitated or hospitalized. And then the stage when you are no longer on this earth and you're now in heaven. And there are documents for each of those stages of your life. The first stage where things are going along fine, you want to have your power of attorney in place. You may have your a trust in place. You're giving people the ability to make decisions for you. And then if you are hospitalized, then you have the person to make medical decisions for you. And then with the living will, you are able to direct how you want to have your last stages. And so those things, if you have those things in place, if you get to a point that you become incapacitated, you don't necessarily have to worry about guardianships, and those are very expensive to have guardianships. The court appoint guardians, because you have your what we call advanced directives, you have your power of attorney in place, you have your healthcare surrogacy in place, you have your living will in place. So there's no need for the court to get involved to dictate what happens to your property and what happens to your person. Next one. People ask a lot about living trust. In fact, Ms. Salazar was talking about living trust. Is a living trust is a means of putting all of your assets in an entity that you can control, particularly if it's a revocable trust that you can control. And so that should you become incapacitated, then again, we talked about guardianships. It's not necessary because you are usually the trustee. And then if you are not able to continue as trustee, you have appointed a successor trustee to make financial decisions for you and other decisions for you. And if upon your death, you have identified in that trust that when you are no longer the beneficiary of that trust, then you have determined who you want to receive the assets of that trust. And that way you've avoided probate. And the beauty of it too is that if you have real estate in 2 different states, you can put the real estate in both states into that trust. And now you don't have to probate in either state because your trustee can make those stand in your shoes. A living trust is I don't say that everyone needs a living trust. I mean, the beautiful thing about it too is that you don't need a separate Social Security number because the law treats it as, because it's revocable, it treats it that if it's you, but the beauty is that you're avoiding probate. You put your bank accounts in that trust. The banks are familiar with that. Again, the bank accounts now pass outside of probate. Like I said, we said the real estate passes outside of probate. If you want to have someone else, you can just say, I no longer want to act as my trustee, so I'm going to resign and have the successor trustee appointed. So, but if you don't have a lot of assets or property in 2 different states, then you want to ask yourself whether or not it's worth doing, because if you don't fund it, if you don't put anything in it, then it's no use. You got to put the stuff in it. It's not enough just to have a document, but not having funded. Next one. Then you have an irrevocable trust. Now, the difference between the revocable trust and the irrevocable trust is that the revocable trust, you can change it during your lifetime. You can amend it, you can revoke it completely, you can change it. An irrevocable trust, you really can't, for the most part, you can't change it. It has its own FEIN number, but by virtue of being irrevocable, then it's not treated as your asset. So if you then on here too, we have a special needs trust. If you have a child that needs public benefits, then what you don't want that child to be able to have assets accountable to them. So an irrevocable trust works for that, because those assets are not, that child can get the benefit of those assets, but not have those accounted to them because they have no control over it. You can also have an irrevocable life insurance trust. And what that does is that take the life insurance away from you, and it's not counted as an asset upon your death because you have no control over it. You can't serve as a trustee of it, but you have no control over it. Next slide. Next slide. Okay. We talked a little bit about wills. Like I said, you have the trust, the living trust, you have the irrevocable trust. Then what you have is the will. Now, even if you have a trust, you still have a will. We call it a pour over will, because whatever you forgot to put in the trust, then the will place it in the trust for you. But the trust, I mean, if you don't have a trust, then the will is basically setting forth your wishes upon your death. But for the will to be effective, it has to be probated. I've had someone say, well, I have this will, I'm going to go and give this person that person, this real estate, that. I said, no, you can't do that. You have to probate the will, and then the personal representative of the will would then stand in the shoes of the deceased person and then can make those decisions. Can probate the, transfer real estate if that's a requirement in the will, or can transfer personal property or pay the bills, whatever, but the will has to be probated if there is anything that has not been transferred by some other means like a trust or outside of probate. Your will can also include a trust. We call it a testamentary trust. And what that is that you may have a situation, and we had one in Georgia, well, where the mother gave the son his share outright, but said that the daughter, because of her mental instability, her money had to be covered. A trustee had to be in place to oversee that money. And again, we talked about a special needs trust. You can create a special needs trust in your will because you want, if you're giving something to a beneficiary that has public benefits, and you're trying to make sure that that person does not lose those public benefits. Next one. The will can also name a guardian for your children. I mean, remember that there was a big case in Florida where the grandparents were fighting over the child. It's helpful when the parents actually say who they want to have custody should they pass away before the children are no longer minors. And the will you also includes who you would act as the personal representative. And if you include a trust in your will, then you would have a trustee. And what the will can also include is something called postponement language. And what that means is that sometimes you may leave something to someone that's under 18. And if that occurs, certain other laws may come into being, meaning that if you leave $25,000 to a child that's under 18, and you don't have language in your will that says that a trustee or someone will watch over that until that child turns 18, then a guardianship has to be created to receive the monies, because the statute says that if a child gets more than $15,000 and don't have and it's not going to the natural guardians which would be the parents for the benefit of that child, then it has to go into a guardianship. So in estate planning, you got to make sure that if you're going to give something to somebody that's underage, that there are provisions to be able to allow that distribution to occur so as not to cause a lot of other expense. And what your wills can do is also direct how you want to leave property to, say, children or descendants, because you can leave it in one. If you saw the word per capita in a will, then that means that only the living children would receive. But if you see a word called per stirpes in a will, then that means that if a child is no longer living and that child has children, then that child's children would receive. So just a few words here and there can make a complete difference in what your plan is. So that's why it's so important to understand what you want and make sure that the document sets forth what you want. And sometimes we don't think about, about giving gifts to church and charities. We sometimes think about just leaving it to children or leaving it to a spouse, but you may be donating to a church, a charity, or something all your life, and this would be an opportunity for you to leave a final gift. And so I encourage that in your estate planning process. Next one. Your homestead is, Florida is very protective of homesteads. So in when you pass away with a homestead, then your creditors, other than the mortgagee or the tax property appraiser or homeowners association, those things that run with the property, your property is protected from other creditors like medical bills and credit card bills. Those, you can have 1 million of those in your claims filed against you, but the court can still enter an order designating your homestead, and it takes it right outside of your estate, and those creditors don't have any place to go in terms of, and oftentimes the homestead is the biggest asset in a person's life, and so it is protected if it's deemed homestead by the court. There's another way to protect property and pass outside of probate is a life estate with a remainder. It's called a ladybird deed, and what that does is that if you have your home and you say, well, I want my children to get it, that's all I have, I want my children to get it, and I don't want to go to probate, then one way to consider it is to grant yourself a life estate and a remainder to the children, but make sure when you grant that life estate, you retain the right to be able to sell it, mortgage it, or encumber it in any way you want. Because if you don't retain that, and I've seen this happen too, a gentleman wanted his nephew to have his interest in this property, so he had a life estate, and his nephew had a remainder. And then the uncle realized that he needed to sell his property, and his nephew wouldn't sign off on the deed. So therefore, he was stuck because he could not sell the property that the nephew had no involvement in securing for him in the first place. But if he had the life estate with we call it an enhanced life estate, then he could have still sold that property, notwithstanding the nephew being on the property, which is that to me is one of the best means of avoiding probate, but at the same time protecting your rights. And because it's a life estate, you keep 100% of your homestead exemption. If you prepared a life estate with if you prepared a deed saying, I want my daughter or my son to be on it, and you just have them on it as a joint owner, then you could lose half or whatever percentage of your homestead exemption, because now you don't own 100% of the current present interest in the property. So when you're thinking about placing someone else on your deed, make sure that you know how you want that done and the consequences of whatever you're doing. Next one. Another way to planning is putting persons on your bank accounts, and you have to be careful about this, because I've had people come in and say, well, I put my daughter on my bank account because I know that she's going to do what is supposed to be done. But you have 2 or 3 other children. How did you put your daughter on the bank account? If you put your daughter on the bank account as a joint owner, upon your death, that account belongs to your daughter. Was that really your intent? Maybe what you wanted to do was just to put your daughter on your bank account for convenience, to help you with writing checks and things like that. And upon your death, that role it ends, and then that account just is a part of your estate. So if your intention is that you want all the kids to get it, then maybe you want to put all the kids on as beneficiaries of your account to get an equal percentage. But if your intent is that you just need somebody on there to help you with your bills, then make sure that that's the type of account that you're creating, and you're not creating one that could result in something that you did not intend, because unfortunately I've seen siblings and the one that's name is on the account take everything, and that was not necessarily the intent. And on, if you have a living trust, like I said, don't forget to fund your trust with your bank account, because if you don't put the bank account in the trust, then it has to now go into probate, and that was not your intent in the first place, because the objective is to if your objective is to avoid probate, then you want to make sure you do everything that you need to do to avoid probate. Okay, then next one. Last slide is that asset protection. People ask about asset protection. If you believe that in the next 5 years, because Medicaid has a 5-year look back period. So if you believe in the next 5 years, you're going to need long-term care in a nursing home or even at home, and you want to start planning for that, then you know that Agency for Healthcare Administration, they look to see what assets you have, and they have something called countable assets. There are some assets that are not countable, like your home, your vehicle, a funeral plan that's irrevocable. There are a number of things that's not counted, but most things are counted. And so you might want to start planning on how I can either create irrevocable trusts or other things to be able to have those things not counted. But that's but I just threw that in just for thought, because that's not so much estate planning, that's asset protection, but that's something that we're going to have to deal with too. Okay, then, but I see that there's some questions in the chat room for me. Okay, then. Would like to know info on transfer of deed, Lady Bird deed. Like I said, basically, if you own whoever owns the property now, and if you want, if a husband and wife own the property, and the husband and wife want a child to ultimately have the property, what I usually would do is I would say that the husband and wife owns the property, and upon the death of the last of them, then the property would go to the child. And I've even had situations where the husband, the wife says, well, this was my property and I wanted to go to my daughter, but I know that my husband have to be on it, but I want a Lady Bird deed. So we give the right to be able to sell and encumber it to the wife. But if the wife dies first, that right does not inure to the husband, so that the husband would only have it as a life estate, and then the child would still get it. So it's all being very creative in terms of making sure that that whatever your plan that you want to accomplish is accomplished. So I thank you for this opportunity to be able to talk with you. And if you have any other questions, hopefully I didn't talk too long.
Well, there is another question in the chat. It says, will taking someone off my deed affect my homestead?
Only if you're taking yourself off the deed. I mean, it's a, that's if you are on the deed with someone and you take the other person off the deed and you're still on the deed, then you have, and that's still your homestead, then you have 100% homestead. if I understand the question.
Thank you for that. Now there's another question. How long is the probate process?
It depends. If you have, there is a immediate probate, and then there is formal probate. Formal probate is usually when you file the documents with the court, and the court will appoint a personal representative. Then a notice has to run in the newspaper. It's called a notice to creditors. That it runs, creditors have 90 days from the date of the first notice to file claims with the in the estate. If you're aware of a creditor, you have an obligation to notify that creditor that notice to creditors have run. After that 90-day period, then you can begin the process of closing the estate. That's dealing with creditors, dealing with whatever is necessary to close the estate. So that process, if everything goes smoothly, it usually takes between 5 and 6 months. If things don't go so smoothly, I've had estates open for years. It just depends upon whether or not there's litigation, whether or not there's an issue finding, dealing with creditors. There are a number of things that could come up, but on a good situation, it's at least 5 months. Immediate probate is when there's if all it is a homestead and there are no assets, or the assets are under $75,000, and the funeral bill is paid, then you can do something called a summary administration. And I've gotten the summary administration within a week. And if a person, even with a big estate, it has been deceased more than 2 years, you can get it done quickly, because after 2 years, that's a mandatory barrier for creditors to file claims. So 2 years out, with trust or anything else, creditors are barred from claiming against an estate.
Okay.
Hope that wasn't too much information.
No, that's great information. I have another question. Heirs property is a hot topic. Talk to us a little bit about heirs property, what it is, and how we can avoid it.
That's been the whole seminar, estate planning, because I've had a situation where, well, basically what heirs property is a person passes away with no will, no trust. But so what the law does is it says that the statute has in place who would get your property if you did not provide for who you wanted to get your property. And that could be if you're a father and you have your wife has passed away and you have 4 children, then those 4 children will get your property. But what happens is one of those 4 children is deceased, then but have 3 children, and then those children get your property. Would get that one third interest would be divided. I've had a situation where I had to give 64 people an interest in property because of the heir situation. It was maybe 50 years from the time the person died until it was resolved. And so some people got $220 and some people got $3,000. But then the legal fees were ridiculous because of all of the tracing and the family trees to try to come up with the percentages that each family tree was entitled to get. So the best way to avoid heirs property is to plan. That help?
Yes, thank
Okay.
you. I have one more question. With inherited property with multiple names on the deed, Is it a good thing to have 4 or more names on the property?
Well, if you have no choice to have 4 or more names on the property, it is what it is. The problem with that is that if anything happens to one of you and that person had no will, then that 1/4 interest then goes to that person's heirs. And now a property that was owned by 4 people may now be owned by 12 people. You almost come out better putting the property in a trust or something, and then and that trust will show how have a trustee who can sell the property and distribute it accordingly. But the more people you have on a deed, the more challenging it becomes, if everyone is not planning for what happens if that person is no longer living. Hopefully that made some sense.
Yes, thank you. I don't see any more questions in the chat. Thank you so much, Ms. Simmons.
Thank you.
We appreciate you joining us for this very, very important conversation about planning, estate planning, making certain that you have all of your paperwork in order to make certain that you are leaving your property to the persons you intend to leave your property to. And also to avoid any other issues after that. Let's see, one more chat says, yes, thank you so much for your presentation this evening. I do want to invite everyone back next week. Our next webinar is called Estate Planning Part 2, Leaving a Legacy, the different ways you can leave a legacy. And we're going to talk about what's life got to do with it. We'll talk about what the LIFE means to you when it comes to your estate planning and how to fund your trust, as Ms. Simmons mentioned this evening. Again, thank you so much. I'm going to turn it over to Helen.
Yes, thank you so much, Ms. Salazar and Ms. Simmons. We had a conversation today that a lot of people don't want to have at home. They don't want to talk about the what ifs. What if, I get hurt? What if I'm in the hospital and can't make decisions for myself? What is going to happen when I pass away? But these are important conversations that we need to have, and we need to have a plan in place. And I just thank you again for taking the time to share all this important information with us. And at this time, I'm going to ask everyone to please point your cameras to the QR code that's on your screen. We have a webinar evaluation that
I think Helen might be a little frozen. Ms. Simmons has something else she'd like to add in the meantime. Ms. Simmons?
One more thing with the 4 names on the deed.
Yes.
There is a way to do it so that it could work. You need to have it as joint tenants with right of survivorship. And then that way, upon the death of one, then the other 3 would get it. So, I mean, there are ways to do it so that you won't create the havoc that I just said. And I apologize, but that just dawned on me that is another way to do it.
Okay. Ms. Simmons, if you will, please place your contact information in the chat so that those who are listening in and who will view this later on will know how to contact you. And for all of our participants, at the end of our webinar next week, we will have a list of all of our presenters and all of their contact information. But in the meantime, I'm pretty sure, I know that I have some questions, and I'd love to sit down and speak with you about making certain that my plan is shored up for my family as well.
Well, one good thing is I don't charge a consultation fee.
All right. Thank you so much.
Okay, I apologize. I got lost in cyber world for a little bit. Can everybody hear me okay now? All right, again, I just want to thank everyone. Thank you, Ms. Simmons, for leaving your contact information in the chat. And like I said, we're going to give everybody an opportunity to please complete the webinar evaluation. This is very important information for us. We are really about giving you content that's important to you, and we just want to see how we're doing and seeing how we can improve for our next session. And at this time, I'm going to ask to go to the next slide, please. On your screen, what you will see is our program team. You can take a look at everyone who has played a significant part in getting this program out to you all. Next slide, please. And if you ever want to contact us, if there's something that you didn't have an opportunity to ask today, you can always contact us at this address. It's tclinksnts@gmail.com or treasurecoastlinksinc.org. Next slide. And again, we thank you. We thank you so much. Thank you for everyone that has partnered with us. We've had an ongoing partnership with BB&T SunTrust, now Truist. And we thank Ms. Simmons again and Ms. Salazar for joining us this evening. And we wish you all an amazing Thursday evening, and we'll see you next week. Good night, everyone.
Good night.
Good night.
Thank you.